Welcome to Muscalaw Radio, a program dedicated to criminal defense. Muscalaw is a criminal defense firm with offices throughout Florida, including Broward and Palm Beach counties. Your host today is attorney Harley Brook, a full-time associate of Muscalaw. Mr. Brook has been practicing criminal law for 12 years and has devoted his career to representing clients on criminal defense matters. Mr. Brook is a former statewide prosecutor and a former assistant state attorney. In addition, he served as a magistrate presiding over traffic matters. If you or someone you know is under investigation or accused of a crime, or if you have any questions related to criminal law, you don't want to miss today's show with attorney Mr. Brook. To watch this show stream live, visit muscalaw.com. That's muscalaw.com. And click on the radio link. Now, here's attorney Harley Brook.
Good afternoon, folks. Pleasure to be here again. It's my second time. Very excited to do the show once again. And again, if anyone has any questions, please feel free to call the show at any time at 1-888-565-1470. That's 1-888-565-1470. Today we're going to talk again a little bit more about DUIs particularly. And today we're going to tailor the show around strategies for success, ways that DUI cases can be successfully defended and lead to a successful outcome for folks that are accused of those types of offenses. Now, the first thing I wanted to discuss was the fact that in every DUI case, there are two separate facets of it, or two separate cases that are going on at the same time. One of them, of course, is the criminal matter, which everyone knows about. You get arrested, you have to go to jail, be booked, and then, of course, have to deal with the criminal prosecution thereafter. But the other one, which can have also grave consequences to folks that are being accused and arrested of DUI, is the suspension of your driver's license by the Department of Motor Vehicles. Folks that are arrested for a DUI and that subsequently blow over a .08 or refuse to give a sample of their breath will have their driver's license suspended for a period of up to 12 months on a first-time refusal and a period of 18 months on subsequent refusals. So, for folks, particularly in the state of Florida, where driving is just so essential to your livelihood, the suspension of a driver's license is something that is very dramatic, can have dramatic consequences to a person's life, their employment, livelihood, things of that nature. So that administrative suspension of the driver's license is something that is important and has to be dealt with along with the criminal defense side of things. Now, the way the process works is that for 10 days after the DUI arrest, the DUI suspect, and I do emphasize the term suspect because at that point nobody has been convicted, the person is only being accused of driving under the influence. Anyway, the suspect has 10 days to be able to drive on their DUI citation. Essentially, the officer will take their driver's license and keep it, and the person will be able to drive for 10 days with the actual DUI citation that they received. Now, that's assuming, of course, that their driver's license was in perfect condition prior to that. In other words, wasn't suspended for any reason. So that person's going to have 10 days to be able to drive on the ticket. What happens after that? Well, their license is going to be suspended. However, the person has, the suspect has the option of appealing that driver's license suspension through a process called a formal administrative hearing. And what that entails is basically appealing the driver's license suspension through the Department of Motor Vehicles. And a good criminal defense attorney, DUI defense attorney, will also handle that for the client in addition to the criminal side of things. Our particular firm, Muska Law, has an attorney that is dedicated exclusively to these formal administrative hearings. Her name is Rebecca Sinalia. And we'll get her on just a little bit later here in the show. Recently, within the last year or so, Florida law has changed to allow folks that are charged with the first offense, DUI, to actually waive the formal administrative hearing and go right to a hardship license. A hardship license, for those of you that don't know, is basically a license that is for business purposes and other basic necessities of life, basically, employment, religious, medical, things of that nature. So for folks that are accused for the very first time of a DUI and have a Florida driver's license, they can actually waive that formal administrative hearing and apply for this hardship license by signing up for the DUI school. So those folks actually have two different options, either electing to proceed with a formal administrative hearing or waiving it and going right to a hardship. There are pros and cons to each, and we can discuss that in a little greater detail. The formal administrative hearing is actually an invaluable process that we as DUI defense attorneys can use to our clients' benefit, particularly in misdemeanor DUIs, which are the vast majority of DUIs that come in through the door. And the reason I say that is that because in misdemeanor cases, you don't have the ability to take depositions of witnesses unless you specifically ask the judge for that and the judge allows it. But with a formal administrative hearing in a DUI case, that gives us the opportunity to depose, to essentially ask questions of the arresting officer as well as a breath test officer or any other officers that had an important role in that arrest. Ask them questions under oath, develop evidence that could help us on the criminal side of things, even if ultimately we're not successful on overturning the administrative suspension. So one thing to keep in mind is just because you may be able to waive the formal administrative hearing and go right to a hardship license doesn't necessarily mean you want to do that. There may be defenses even on the administrative side that we can explore that would not only potentially overturn your suspension altogether, but could also lead to valuable information in defending your criminal case. So what I would like to talk about as well now is basically early intervention. It's key. One of the reasons, of course, is because again, you only have 10 days once you're arrested to file for the formal administrative hearing. So it's important to get on that process very quickly so that you can continue to keep driving. Here in Florida, of course, we don't have a great public transportation system. Driving is key to one's livelihood, particularly in this state. If you get arrested for a DUI in New York City, well, probably not as big of a deal unless you're a cab driver. But in Florida, most of us are heavily reliant on our ability to drive to go ahead and go to work and for all other purposes. So it's important to get with a competent DUI defense attorney and get going on your case immediately on both the formal administrative side as well as the criminal side. And I'll tell you why. When clients get with us early on, it gives us the opportunity to speak with the prosecutor and to continue or to start to plant bits of information that will help us in the end to get that best possible result. One particular case that I remember as a defense attorney that turned out into a dismissal was a case where a client contacted me early in the morning, just after my office had opened at 8:30, and came in and said, Harley, I was arrested for DUI, but I did have something to drink, but it was hours earlier. I blew into the breath test machine or instrument, and I blew zeros because again, I had had one beer and it was several hours before I even drove. The officer then said, well, you must be using some kind of narcotic, some kind of drug, and claimed that I refused to give a sample of my urine, which officers will do oftentimes when the breath test comes back at a very low number, or under a 0.08 or zeros. So in this particular case, the client walks into my office. He says, I wasn't drinking, at least not for several hours prior to the arrest. I've never done a drug ever in my life. Don't even know what one would look like. And the officer is claiming that I refused to give a sample of my urine. Now, here's where this became crucial. Early intervention was absolutely crucial in this case. I said, okay, so if you take a urine test right now, what is it going to show me? He said, well, I told you, Harley, nothing. I said, then go do it right now. He did. Sure enough, negative for all whatever types of narcotics that he was tested for. What did I do then? Well, I took that test over to the prosecutor, and I said, my client blew zeros, and here's a drug test that he took within 24 hours of his arrest. Negative everything. He absolutely did not refuse to take the urine test, and had no reason to do so, and here's why. Here's the test. Sure enough, the prosecutor agreed with me and said, Harley, you're absolutely right. And the case was dismissed. That was the end of it. So again, early intervention, both on the administrative side and the criminal side, are very, very important to a successful outcome of your case. Again, this is Harley Brook with Muska Law, and if you have any questions in regards to criminal or particularly DUI cases that we're discussing today, please give us a call at 1-888-565-1470. That's 1-888-565-1470. All right, so we're talking about early intervention, and basically getting with an attorney as soon as possible, and the reasons for why that's so important to a positive and successful outcome to your case. Other things that we look at, and again, going with the theme today for strategies for success, the first thing that I look at in a DUI case that comes in through my door and file that hits my desk is, was there probable cause for the stop? As I discussed a couple weeks ago on this show, the officer cannot just willy-nilly pull you over. There has to be what's called probable cause for the stop to begin with. In other words, were you speeding? Was there a defective part of your vehicle, a bad tag light, a bad tail light? Were you committing any other traffic infraction? Were you driving erratically to the point where the officer had reasonable suspicion that you would have been either impaired or suffering from some kind of medical infirmity? There has to be a reason for them to stop you, and if there isn't, then your whole case with the proper motion to suppress should go away. And this is very, very important because we've had cases successfully dismissed on this basis. As I've mentioned in the past, cops, officers, deputies are like anyone else. There's great officers and ones that sometimes will, how can I put this, try to manufacture a probable cause for the stop. One example that I gave before, where we were successful in obtaining a dismissal for our client, was the officer claimed that my client had a bad tag light, and that was the reason for the stop. So now the good thing is that on the vast majority of DUI cases, you're going to get a video, and usually that video will show the vehicle prior to its being stopped, and then later on the field sobriety exercises, which we'll get into a little bit later. In this particular case, the vehicle clearly showed that the tag light was in fact operable. Well, what did that mean? Well, that means that the officer didn't have probable cause, because on his police report he stated that the only reason for the stop was a bad tag light. So what did I do? I went to the prosecutor and I said, probable cause allegedly here is a bad tag light. Take a look at the video. The video was clear. This was at night, and you could clearly see two functioning little light bulbs above the tag. Clearly there was no issue with the tag light. The prosecutor had no choice but to agree with me, and in order to avoid me filing a motion to suppress that stop, which would have gone in front of the judge would have seen the video, and ultimately the judge would have granted the motion and dismissed the case. The prosecutor went ahead and said, "You're right, Harley, the tag light was working. We're going to dismiss the case," and that's what they did. There are numerous stories that I hear all the time of folks leaving a bar and seeing an officer immediately pull them over thereafter. Oftentimes, law enforcement officers will position themselves outside of establishments where they expect folks to come out of impaired by alcohol, such as bars and taverns and places like that. And a lot of times they will have the requisite probable cause for the stop. Sometimes they'll have the quote-unquote bad tag light. And, one of the things we absolutely look at first and foremost is, was there probable cause for that stop? Because if there wasn't, the case should go away. We file a motion to suppress. Oftentimes, if the prosecutor agrees with what we're arguing, they'll go ahead and dismiss the case before we even have the hearing. If on the other hand, they feel like they have an argument against our motion to suppress, we're going to go ahead and set it for a hearing, have the judge hear it, and then the judge will make a determination as to whether or not there was probable cause for the stop, and go from there. So that's one of the keys for a successful defense is, was there probable cause for the stop? First thing that happens in a DUI arrest, obviously, is the stop of the vehicle. A lot of folks like to ask about Miranda warnings. We get lots of calls from clients and potential clients that said, well, Harley, they never read me my Miranda rights. Well, they won't in a DUI case, and frankly, they don't have to. The purpose of Miranda warnings is basically to inform the suspect that anything that they say can and will be used them in a court of law. It is not essential to a DUI investigation. It's not even essential to an arrest. The only thing it is essential to is whether or not statements made by the suspect as a result of interrogation, whether those statements can come into court and be admissible. So Miranda warnings are often not read in the process of a DUI. What officers will do is usually, if they suspect that somebody is impaired after they've made the stop of the vehicle, is they'll ask them to perform field sobriety exercises. And that's another area that we concentrate on. And in fact, Mr. Muska, John Muska, the owner and president of our firm, is actually certified in field sobriety exercises. And that's something that we really look at as well, to see if there were any issues that we can seize upon to attack the case and get a good result. In regards to the field sobriety exercises, there are a number of factors that need to be considered. Was the suspect properly instructed on the field sobriety exercises? Did they understand the exercises that they were asked to perform? If the officer haphazardly says, okay, take 9 steps, turn around, come back, and take 9, that's not a proper instruction, and chances are the person was not aware of how they had to do it exactly, so there's no way that they could perform it up to the level that the law enforcement officer is expecting. So, one, was the suspect properly instructed on the field sobriety exercise? And if so, did they understand it? Were there any language barriers? If the client is a foreign client or a non-native speaker, did they actually understand the field sobriety exercises being explained to them? And I'll bring in another example where I was successfully able to have a case dismissed. This was actually at a checkpoint. The client was Haitian, and in the video you could clearly tell that he was agreeing with everything, kind of nodding, and did understand to an extent the instructions, but did not perform exactly as told. Well, what he didn't do right was follow the instructions correctly, but you could tell that physically speaking, he was nailing them. He was doing them absolutely perfectly. But he may not have done everything exactly the way he was told. Well, lo and behold, after he's arrested for a DUI, he blows, I believe, a .04 is what he blew, so only about half the legal limit, and yet, was still facing the DUI, because of course the breath is only one piece of evidence of the entire equation. Well, obviously we were able to explain the fact that any failure to perform the field sobriety exercises as exactly instructed was due to a language barrier. And in fact, if you look at his physical ability to perform those field sobriety exercises, it was perfect. And then, of course, once you couple it with the low blow, then obviously at that point that was a recipe for a successful outcome, and we were able to do that. So again, did the suspect understand, is there any kind of language barrier? Another aspect that we really seize upon is, were the field sobriety exercises appropriate for that particular person? And by that I mean, was this an elderly suspect? Was this a person who had some kind of a medical infirmity that just would make it impossible for them to perform the field sobriety exercise? You'd be surprised how many times I've had elderly clients asked to perform the same types of field sobriety exercises as everyone else, or perhaps somebody with a bad knee or something to that effect. Now, the fact of the matter is, there are 3 field sobriety exercises that are most commonly asked by law enforcement to be administered on suspects. And that's the horizontal gaze nystagmus, which is a little lighted pen that they put in front of your face, move side to side. They're looking at your eyes for whether there's a smooth pursuit and things of that nature. There's the walk and turn, where you walk nine steps heel to toe, do a series of pivots, and then come back the same way. And then there's a one-legged stand, where you basically stand on one foot with the other foot up. You're asked to count to 30, and the officer will look for particular clues during the performance of those field sobriety exercises. Well, if you have an elderly person, it's not recommended for them to perform those types of field sobriety exercises. There are actually alternate ones that can be given. And if the officer, knowing that the person is either very elderly or has some kind of a medical difficulty, they should perform those alternate field sobriety exercises, because the results, frankly, are not going to be really indicative of whether or not the person was actually impaired. It might only show that that person was older or had some kind of a medical infirmity. That has nothing to do with their ability to operate a motor vehicle. Again, if you have any questions, please feel free to call in. Your toll-free number is 1-888-565-1470. That's 1-888-565-1470. We're going to take a quick break, and we'll be right back.
You are listening to Muscalaw Radio with offices throughout Florida, including Broward and Palm Beach counties. If you have questions about criminal law or related matters, call into the show at 888-565-1470. That's toll-free, 888-565-1470. Join us every Thursday at 4 p.m. for Muscalaw Radio, a program dedicated to all criminal defense matters. Joining us live now in our studio, here's attorney Harley Brook.
Okay, so another aspect that we look at, of course, is whether or not the client blew or gave a sample of their breath or refused. I talked about this briefly on the last show, and the common perception out there is never to blow. And while that may be good advice in most situations, it's not necessarily good advice in all of them. We've had clients that have told us that they weren't drinking, or perhaps had only one alcoholic beverage within a matter of a couple of hours. In those situations where it's clear that the person would not be impaired to the tune of a .08 or above, that may be a situation where the person may actually consider blowing, particularly if they haven't had anything to drink at all. So we'll talk a little bit more about the breath test just a little bit later, but on the line here I have attorney Rebecca Sanalia, and she's going to talk a little bit more about the formal administrative hearing that I spoke about in the beginning of the show. I had hoped to have her earlier on, but she is available now, so we'll go ahead and get her on, and she can discuss a little bit more her experiences and success stories as far as the actual formal administrative hearings. Rebecca, are you there?
Yes, Harley, I'm here. How are you?
I'm doing very well. Thank you for joining us. And again, Rebecca, today we're talking about strategies for success in defending DUI cases. And I mentioned previously to our listeners that you are a devoted DMV attorney and handling these formal administrative hearings for our firm, something that sets us aside and apart from other DUI defense firms, and have had a great deal of success in handling these formal administrative hearings. I'd like you to tell us a little bit about how you've been able to be successful in handling these formal administrative hearings before the Department of Motor Vehicles.
Yes, Harley, I'd be happy to. Challenging the automatic DMV driver's license suspension associated with a DUI arrest is a completely separate matter from the criminal charges that proceed in the court. This is a civil action that operates under completely separate rules that are somewhat difficult to master and understand. In my personal opinion, there's some barriers and challenges in the way this DMV driver's license suspension system is set up to make it, in my opinion, somewhat unfair to start with. But that being said, it is still absolutely possible to win these hearings with the right experience and understanding of this very complex area of the law, and we do win them all the time.
How do you do it?
There's a variety of different ways that we do it. Sometimes these hearings are won on technical grounds. For example, if an essential witness who's been properly served with a subpoena fails to appear without notifying the hearing officer ahead of time, or other technical grounds could include things like if the arresting officer fails to submit all of the required documents, or sometimes all of the required documents are submitted, but a trained and experienced attorney would be able to determine which of those need to be properly signed and attested, which could also be grounds for invalidation. And we also win some of these hearings based on the merits of the case, and those are the best kinds of victories, because winning the winning argument in the DMV case can sometimes also be carried over and used to defend the person against the criminal charges in court as well, and that's where there's a lot more at stake for our clients. Basically, we focus so heavily on these DMV challenges, not only to try to win the driver's license back, but also as an opportunity to use this DMV process to establish ammunition and defenses to carry over into the criminal court case as well. A few examples of some of the DMV cases that I've won on the merits can help illustrate the value and importance of the DMV challenges, establish the importance of how this DMV challenge can help us win the license, as well as working toward a positive outcome in the criminal DUI case as well. One that comes to mind for me right now is a client of mine who had submitted to the breath test and blew over the limit, and the DMV suspended the driver's license, and we proceeded with challenging that suspension. And I conducted my own independent research and investigation into the breath testing instrument that was used in this case. Through my many years of working on these cases, I've really learned how to navigate some very complicated data and documents to determine whether there's a problem with the breath machine itself, or how it's operating on a daily basis, or with the inspections or repairs or problems or things of that nature. And in this one particular case, I detected a discrepancy with the .08 control canister on the machine. In each breath test, there's a control test at the beginning and end of the breath test that measures this pre-made .08 solution to make sure the machine's working. So if it measures close enough to the .08 at the beginning and the end of what we know is already .08, that's evidence that the subject's two breath samples in between are also being measured properly. The machine's working properly throughout. And what I found in this particular case is a discrepancy in the cylinder number and expiration date for the control test canister on this instrument between the subject breath test and the agency inspections conducted each month by the agency inspector. So I subpoenaed the agency inspector, which is somewhat of a rare move in a DMV case, but in this case I felt it was appropriate. And when I presented him with overwhelming evidence of the issue that I had discovered, he was forced to admit that he didn't know why the cylinders didn't match up. He had to admit that the only logical explanation was that an unauthorized cylinder change had probably been conducted at some point but not properly recorded. And he had to admit that he didn't even know what cylinder was actually on the machine, and most importantly, he was forced to admit that the proper protocol was not followed, and thus the breath testing instrument failed to substantially comply with the rules and requirements. In that case, I presented the hearing officer with overwhelming evidence to support my argument, as well as taking the testimony of that agency inspector, and ultimately all of those extra efforts, hard work, and knowledge of some very complicated breath machine protocols paid off because the hearing officer ruled in my favor, and the client's full driving privileges were reinstated. Now, subsequently, in the criminal DUI court case for that client, based on these same arguments that I was able to establish through the DMV challenge, that DUI was dismissed, and it was reduced to a charge of reckless driving, and the adjudication was withheld on that reckless driving, which means that my client wasn't convicted of anything at all, and a lot of that had to do with what I did in this DMV challenge case.
And that's huge. That's huge because, sometimes a successful outcome, or in a DUI case, if you can get a reckless driving out of it, that's already a successful outcome. But if you can receive also a withhold of adjudication in that process, that's even better because, like you said, that's not even a conviction of any kind, not even for the reckless driving. So that's huge, and it all started with your work on the formal administrative hearing side, and that's how we really tie things in together. For those of you folks that are listening, with our teamwork approach on these DUIs, one successful effort on the formal administrative hearing often leads to a successful effort on the criminal side of things. Now, Rebecca, I know we've worked on a couple of cases together where the clients had high breath alcohol contents, and you were able to beat those on the formal administrative hearing because simply the agency inspection reports were either off, in other words, they provided the wrong one, or perhaps didn't even provide one. Can you explain to us a little bit more about that?
Well, in a suspension case for an unlawful breath alcohol level, meaning above a .08, one of the required documents to be in evidence in the DMV suspension case is the monthly agency inspection that's conducted on the breath testing instrument to prove that it's operating properly. And that document, it must be there. And sometimes the Bureau forgets to put that inspection into their file, or sometimes they'll make a mistake and put the wrong inspection. I look at these very carefully, and actually several of my clients have been able to capitalize on this, whereas somebody with a little less attention to detail may not have caught it. An instrument that's maybe one serial number off, or one digit off on the serial number from the instrument that was used in this case, or they put the wrong month in there or the wrong year in there. I've had all of those things happen. And that's an example of winning a DMV challenge, on one of those technical issues. A trained eye knows what to look for and how to capitalize on it. But again, the victories that I cherish more so than the technical victories are the cases that I win on the merits, and I'd be glad to discuss a couple of more of those if you'd like to hear about them, Harley.
Absolutely. Let's hear about the merits.
Okay. Another one of mine, and this one was actually really fairly recent, involved a gentleman who was a snowbird from Massachusetts, and he would spend a portion of his winter down here in Florida to enjoy our beautiful weather. But unfortunately, while he was here, he was arrested for DUI. And after the arrest, the officer asked him if he'd be willing to submit to a breath test, and he wasn't sure whether he wanted to take the breath test or not, so the arresting officer read the implied consent warning to him. Now, the implied consent warning is the speech that's required for the arresting officer to read to a subject, letting them know what the consequences are if they refuse to submit to the breath test. Basically, those consequences are a 1-year license suspension for a first refusal or an 18-month license suspension for a second or subsequent refusal. And a second or subsequent refusal can also be the basis of an independent misdemeanor charge in the court. So after hearing those warnings, my client decided to go ahead and submit to the breath test, and he subsequently blew about twice the legal limit. And everything in evidence, in the documents and reports, everything looked like this entire exchange was handled properly and lawfully, and there was nothing about it to really alarm me. But I never assumed that everything was proper just because the police report and documents say it was proper. As Harley was discussing a little bit earlier, the best piece of evidence to evaluate everything from start to finish in a DUI case is the video, because it shows the truth. Unfortunately, not all DUI arrests are recorded, and even for those that are recorded, it's actually quite rare that I'm able to obtain a copy of that video prior to the DMV hearing to benefit in this process. And that's simply because the DMV case moves very fast and the criminal case moves much slower, but we can only obtain the video through the criminal court case, and it's typically not available to us by the time the DMV hearing happens. But in this particular driver's case, the DMV hearing ended up being delayed a couple of times, so there ended up being a sufficient amount of time for that video to become available to us through the criminal case so I could review it before questioning the arresting officer. And again, although there was nothing in the police reports to raise my suspicion at all regarding the handling of implied consent, I was pleasantly surprised when I was watching the video. The video revealed that when my client was asked to take the breath test, my client told the arresting officer that he'd be going back to Massachusetts in about a month, and made statements that it wouldn't matter if he was suspended here in Florida because he wouldn't be here. He was going to be back in Massachusetts where he had a valid license. Well, the arresting officer then told my client that if he refuses to take the breath test, his license will be suspended whether he's here in Florida or if he's back in Massachusetts. The officer further told him that this refusal suspension would apply everywhere. So based on that statement, my client agreed to take the breath test and blew twice the limit, and the suspension was issued based upon the unlawful breath alcohol level. Based on my significant DUI experience, I knew that the arresting officer provided my client with incorrect information. I know that the Florida implied consent law allows for a suspension of a person's privilege to operate a motor vehicle in the state of Florida. Florida has no power or authority to suspend an out-of-state driver's privilege to drive anywhere outside of the state of Florida. Only Massachusetts would have the authority to suspend his Massachusetts driver's license in Massachusetts. So the officer provided completely incorrect information and misstated the law by telling my client that his Massachusetts license would also be automatically suspended if he refused to take the breath test, and thus my client was improperly coerced into submitting to a breath test, but the law requires that the consent to the breath test must be voluntary. I presented the hearing officer with a copy of the video to prove this violation because the arresting officer conveniently could not recall this portion of the conversation when he was testifying at the hearing. I also provided the hearing officer with a judicial decision from a case with essentially identical facts, other than the home state was New Jersey rather than Massachusetts. That case was brought into the court before a judge, and the judge ruled that this misinformation, that the out-of-state driver's license would be automatically suspended if the driver refused the breath test, rendered the driver's consent to submit not freely and voluntarily given, and thus the breath results had to be excluded from evidence. And in my client's case, I was able to get the hearing officer to agree, and the license suspension was invalidated. But in addition to winning this DMV case, my efforts and work really set the stage for a motion to suppress the breath results in the criminal court case as well, which is very important in a case where the breath results are over a .15. And so this is actually an even bigger achievement than winning the DMV case. But that person's criminal court case is actually still pending. But I do anticipate a successful motion to suppress the breath results in that case.
And you bring up a great point, because when there is a breath test of over a .15, that necessarily means increased sanctions and penalties as far as a disposition if the person is convicted of that DUI. So if the breath test can be excluded, the breath test results can be excluded, that means that person would not have to be subject to those enhanced sanctions, such as a higher fine, the need to install an ignition interlock device for a period of 6 to 12 months on a first offense, and things of that nature. So if the breath test results go away, then the enhanced sanctions subsequently could go away as well.
That's correct, Harley.
All right. Well, thank you so much for joining us, Rebecca, and talking a little bit about your success stories for the formal administrative hearing. As Rebecca stated, this teamwork approach really is crucial towards obtaining a successful result in a DUI defense case. A successful result sometimes is a complete dismissal. A successful result can sometimes be reduction of charges to a reckless driving. And when you can get a reckless driving with a withhold of adjudication, meaning no conviction, obviously that's even better. Obviously, the dismissal is the ultimate outcome and what we always strive to achieve. Sometimes it's possible, sometimes it's not, and obviously each case is unique and different, presents its own set of challenges and circumstances, and so we go from there as far as from one case to the other as to obtaining the best possible result for that particular client. So, talking a little bit, going back to the breath test that Rebecca discussed a little bit. Implied consent, as she stated, is potentially a reason for having that breath test excluded if it's not properly read, such as an example that she just gave. There are other factors to be considered in determining whether or not the breath test result is even admissible in court. Was there a proper 20-minute observation conducted, where the officer has to observe the suspect for 20 minutes continuously prior to the first sample of the breath being collected? And that observation can't be a situation where he leaves the person in the room, goes to get a soda, comes back. No, it has to be a continuous observation of the suspect, making sure that during that time the suspect does not burp, regurgitate, put anything in their mouths, things of that nature. So if that 20-minute observation is not done correctly, then that could be a basis of excluding the breath test result as well. There are other things that we look for, such as the agency inspection reports that Rebecca alluded to a little bit earlier. Was there proper certification for the breath test operator? Was it up to date? Things of that nature. So when you have a breath test result, if it's over a .08 or if it's over a .15, it's not necessarily the end of the day for you. We have to make sure that the breath test is actually even going to be admissible to begin with before we concede anything in regards to those results. And again, Even a result over a .08 is just but one piece of the puzzle, one bit of evidence. If we were to go to trial in the matter, simply because a client blew over a .08 does not automatically mean they were guilty of a DUI. A judge would instruct a jury that the person, may be presumed. However, that presumption can be overcome by other evidence. Let's say, for example, somebody blew a .09, and when you look at the video, the person looks pretty good, does the field sobriety exercises very well, and doesn't look impaired. Oftentimes, if you have a blow that's just barely over the limit, with a video that looks pretty good, those are the types of cases that we oftentimes are able to get a reckless driving out of, assuming that that's good enough for us and the client. But sometimes, let's say it's a multiple offender, somebody who has prior convictions, and the state just isn't willing to negotiate anything less than a DUI because of that. Well, that's a circumstance where we can go to trial and potentially overcome that presumption that the person was impaired by showing other evidence that, in fact, the person's normal faculties were not impaired. Remember, it is not against the law to drink and drive. It's not. If it were, probably wouldn't have as many bars, taverns, and saloons in this country. What is against the law is to drink to the point where your normal faculties are impaired and then drive. All right, so that's important. That's important information to consider. It's certainly not against the law to have a moderate amount of alcohol prior to driving. As part of my public service announcement, though, if you're ever in doubt, obviously call a friend, call a cab. Don't put yourself in the position where you're going to need me or Rebecca. Call a buddy, call a cab. Don't put your life or anyone else's at risk. However, if you're in the circumstance where you have been arrested, whether wrongfully or not, then obviously you're going to want to contact a competent defense attorney, DUI defense attorney, that's going to be able to give you the kind of work and outcome that you deserve, like anyone else accused of any crime in this country. Again, if you have any questions, please feel free to give us a call at toll-free 1-888-565-1470. That's 1-888-565-1470. Now, other factors that we have used in the past to obtain successful outcomes for our clients include the individual idiosyncrasies of the prosecutor we're dealing with. So it's one of the things that's important for you to consider in your attorney is he familiar with the prosecutors that he's dealing with, that he or she is dealing with? Does he have experience in dealing with that particular county or those particular prosecutors? We've had successful outcomes. For example, I had a client that had a case that, if it were to go to trial, probably not the strongest defense case in the world. However, because of that particular client's credentials, that particular client's age with no priors, and professional status within the community, I was able to actually get that particular client a plea offer to a reduced charge of reckless driving with a withhold of adjudication. Now, it didn't necessarily have anything to do with the facts of the case, but because of relationships that I had and with that office and that particular prosecutor, not that she did me anything more than she would do for anything else, but because I knew the types of things that particular prosecutor valued, we were able to obtain that excellent outcome for our client, who not only avoided the DUI conviction, but and avoided a conviction of any kind with a withhold of adjudication in the with a reckless charge. So I see we have a little less than 10 minutes here, and I wanted to briefly go over strategies for success in a trial. And I can fill up probably hours and hours of information on dealing with that issue alone, but I would like to briefly touch upon it because I haven't been able to get to it so far. One thing to keep in mind in a trial is jury selection is huge. It's an absolute must for your defense attorney to conduct a proper jury selection. Jury selection is not just the process of weeding out jurors and selecting the best possible jurors for you. Yes, that's obviously one of the, if not perhaps the most important aspect of jury selection, but that's not it. That's not the only thing that we're looking for during the process of jury selection. Jury selection is as much about education as it is about selection. And what I mean by that is jurors need to know, for example, that it's not against the law to have a drink or a few drinks and get behind the wheel of a vehicle. There may be evidence that's going to be uncontroverted in the trial that's going to show that our client was in fact drinking that evening or during the day. But there's no crime in that. And believe it or not, some folks, may think that simply drinking and then driving is a crime. And it's important throughout the process of jury selection, not only to weed out those folks that we know that are not going to be, unbiased towards our client. It's also important to be able to educate the entire panel on things such as this. So we want to make sure also that that potential jurors understand that the testimony of law enforcement officers is not to be given any more or less weight than the testimony of any other witness. Oftentimes, and we've had obviously countless cases throughout the years where clients have had friends that were with them that would testify to the fact that they only had X number of drinks, or that they've known them for years and they certainly did not believe them to be impaired at the time they were driving. Well, a potential juror may, if not properly educated, may believe that that person's testimony perhaps isn't worth as much, or isn't as important as the testimony of a police officer, law enforcement officer. So it's our job to educate them and tell them that no, every witness is to be considered equally. And if there are other factors with which to either credit or discredit their testimony, then so be it. But simply because somebody takes the stand and is wearing a badge does not mean that their testimony is to be given any more weight or credibility than the testimony of somebody who takes a stand who's not wearing a badge. So that's something else that is very, very important to convey to potential jurors. So, cases certainly oftentimes can be won or lost in jury selection. You want to make sure that you have a set of 6 people on that in that jury box that are going to be able to be unbiased. Obviously, we're going to weed out the folks that have had DUI cases where perhaps they were injured or a family member was injured or somebody like that by somebody who was DUI in the past. Obviously, we're going to weed out those people who are clearly not going to be able to be unbiased. But again, it's just as much about education than it is about selection. And so it's important to keep that in mind. And an experienced and well-qualified DUI defense attorney is going to be able to handle the process of jury selection as a process of not only selection but education. And that's only the first step of trials, and certainly we'll have the opportunity to discuss everything that happens thereafter in future shows. But it's a process that most folks may not know how important it is to the resolution of the case. So it's certainly something that I wanted to address. Obviously, the facts and evidence of a case are going to determine whether or not it's in the client's best interest to enter a plea the best possible plea that we can obtain for them, or whether to take the case to trial. Obviously, the stronger the case for the state, the better it would be for us to get the best possible outcome. Relationships play a huge role in that, and our experience in knowing what to relate to the state also plays a huge part in that. So I'll leave the rest of the jury trial process for another day, but I want to thank everyone for listening to me on the show, and I look forward to hosting the show in the near future. God bless.
You have been listening to Muskalaw Radio. Muskalaw is a criminal defense firm with offices throughout Florida, including Broward and Palm Beach counties. Join us every Thursday at 4 p.m. right here on AM 1470 WNN, or log on to muskalaw.com. That's MUSCALAW.com. And watch the program stream live. Listen in again next week, and thank you for joining us.